Hi everyone, my name is Shazia Khan and the unit we'll be doing today is contract law, and the learning outcome we'll be doing today is learning outcome 5, which is to understand the remedies available for breach of contract. Just a summary of what we've done in the last learning outcomes, and then we will be doing the discussion of the assignment. So the first learning outcome we looked at was to understand the principles of the formation of an agreement. So we looked at offer, acceptance, invitation to treat, with example to case law such as Botany and Guile, Poussard. We looked at cases such as Donoghue and Stevenson. We then went on to learning outcome 2, which was to understand the rules that govern the content of a contract. And then we looked at learning outcome 3, which was to understand the elements that affect the validity of a contract, things such as we looked at misrepresentation, mistake, with reference to case law. We also then, in learning outcome 4, we looked at understanding how a contract can be discharged under duress. We also looked at the different ways a contract can be terminated, like performance, agreement, breach of contract, by law, frustration, and we looked at cases again in regards to how a contract can be discharged. We're going to now look at learning outcome 5, which is to understand the actual remedies available for anyone if a contract is discharged or if there's any elements of the contract that have been breached. Okay, so firstly, we'll look at the key terminology, which is unliquidated damages are damages that are payable for a breach of contract, the exact amount of which has not been pre-agreed. This is in contrast with liquidated damages, which are pre-agreed when the contract is entered into. We've got unliquidated damages are a form of compensation which is said to be at large, that is the amount not to be predetermined with the contract is entered into, but is determined by the court, by either a judge or a jury after the breach has occurred. A liquidated damage clause or an agreed damages clause is a provision in a contract that fixes the sum payable as damages for a party's breach. So if a party breaches an agreement or a contract, then a liquidated damage would have a clause in the contract to say they will be payable for damages if anything happens. 5.1, distinguish between liquidated and unliquidated damages. So if you breach a contract, the innocent party will generally be entitled to recover for damages that may arise naturally from the breach. This can often be very difficult to do, as this will involve quite complex analysis to identify the loss and to quantify it. That's where liquidation damages comes in. Think of liquidated in this context as meaning pre-agreed. Instead of having to quantify the loss suffered due to a breach of contract, parties can instead choose to apply a pre-agreed figure to certain types of breaches. Unliquidated damages. Can you claim liquidated and unliquidated damages? In the construction and engineering industries, people are usually concerned with liquidated damages, but unliquidated damages are seldom mentioned. Unliquidated damages refer to the damages that are claimed for unforeseen loss. They apply to a breach of contract that does not contain in a liquidated damages clause. What are examples of liquidated damages? An example of liquidated damages might be out if one or more parties to the contract fail to perform their duties as expected, and the amount determined in a liquidated damage clause is supposed to be a best estimate of the compensation that would be appropriate if the parties of the contract were to suffer a breach. So what is unliquidated damage? Unliquidated damages are a sum of money that cannot be foreseen or assessed by a fixed formula. It is established by a judge or jury. Damages may be categorized as unliquidable when the amount of damage is unidentifiable or subject to an unforeseen event that makes the amount not calculable. The amount of damages decided by court because the parties to a contract had not agreed in advance how much the damages would be for breaking the terms of that contract. Discharge of contracts. Now we looked at discharge of contract in Learning Outcome 4. Now we're going to look at it a little bit more in Learning Outcome 5. Discharge by agreement. So this is parties may agree to bring a contract to an end. Discharge by performance. So this is where parties have performed their obligations under the contract. Discharge of a contract by frustration. So this must be caused by the event occurring through no fault of the parties and must make performance of the contract impossible. So the event must occur after the contract has been entered into. There must be no commercial purpose left in the contract, and the parties must have foreseen the event, must have not foreseen the event. Discharge of a contract by breach, and this is only if breach is a condition. So there are remedies that are available for breaching the contract. Firstly is damages, which is monetary compensation. So this is an unstated amount, which is liquidated, stated amount, which is liquidated. Quantum merit, as much as he has earned. Specific performance is an equitable remedy where the courts might require the parties to perform their obligations under the contract. Injunction, where it's an equitable remedy again, where it prevents the parties from breaking their contractual obligations. Repudiation, so this is treating the contract as having come to an end so that further performance is not required. And restitution, so not a remedy but means giving back a benefit that has been obtained. Supply of goods and supply of services. The Consumer Rights Act 2015 CRA applies to all consumer contracts for the supply of goods, digital content or services made on after 1st of October 2015. Consumer sales contract is a contract for the sale of goods where a trader sells or agrees to sell goods to a consumer. The Consumer Rights Act 2015 does not apply to contracts for the sale of goods made between businesses, private sellers or buyers, or where a person is not a trader sellers or supplies goods to a business. What is a contract for the sale of goods sales contract? It is a contract by which the seller transfers or agrees to transfer the property in goods, the goods in to the buyer for a money consideration called the price. Goods are anything that are tangible and can be moved. If no price stated, the buyer must pay a reasonable price. Then we've got implied terms in sale of goods sales contract. So the trader is the main one who has lawful rights to transfer goods. The goods are of satisfactory quality. The goods match their description. So, you know, if you're selling a box of chocolates or a perfume and the perfume doesn't match its description, the bottle's different, then, you know, there is a breach there. The goods are fit for the purpose. So you buy a Hoover, okay, and you expect the Hoover to, you know, obviously pick up the mess on the floor. And if it doesn't do that, then obviously there are implied terms there. Pre-contractual information is part of the contract. The goods match the same sample model. The service to be performed with reasonable skill and care. Information about trader or service to be binding. Reasonable price and time. And these cannot be excluded from a consumer contract. So it's important that these terms are put into the contract to identify that, you know, we follow the laws regarding sale of goods. The remedies available under the CRA 2015. So reject goods, short term, usually 30 days, replacement or repair, price reduction or reject goods. If the service does not conform to the contract, the consumer has the right to repeat performance and the right to a price reduction. 5.2. Assess the aim of damages in contract law. Unlike the equitable remedies of specific performance and injunction, damages for loss in a breach of contract claim are available as of right. An innocent party may claim damages from the party in breach in respect of all breaches of the contract. The damages may be nominal or substantial. Nominal damages are awarded where the innocent party has suffered no loss as a result of the other's breach, and substantial damages are awarded as monetary compensation for loss suffered as a result of the other party's breach. For an innocent party to obtain substantial damages, he must show that he has suffered loss as a result of the breach, so the remoteness side of it, and the amount of his loss, so the measure of the loss, how much. It is up to the party in breach to argue that the innocent party has failed to mitigate his loss. So damage, there has to be a causal link between the breach and the damage, the but-for test. Multiple causes. So if the claimant can prove that a single factor was the cause of injury or harm, he or she may be successful in his or her claim, even if there are multiple defendants. Measure of damages. So there's measure of damages. This is the method for calculating the damages in which the innocent party is entitled. It covers loss of bargain or expectation loss. The usual aim of the court is to put the innocent party in the position he would have been in had the contract been properly performed. And the case in regards to that was the case of Robinson and Harman 1848, which I'll go through the facts and the issues in this case. So the facts in Harman and Robinson 1848, Harman wrote to Robinson offering him a 21-year lease of a dwelling house in Croydon. He subsequently changed his mind and refused to complete the lease when he discovered the property was worth more than the agreed price. Robinson's solicitor had inquired as to the nature of Harman's title and had been assured he was absolutely entitled to grant the lease. The property was actually vested in trustees, and Harman was only entitled to a portion of the property. Robinson brought an action for damages. The issue in this case was that Robinson claimed that there had been an agreement to grant a good lease of the premises, and in reliance on this, he had incurred expenditure in the sum of £20 in preparation of the lease. Further, he claimed because of Harman's breach of the contractual agreement, Robinson had lost great gains and profits which would have otherwise accrued to him. Harman asserted that Robinson had full knowledge at the time of the agreement that Harman did not have capacity to grant the lease. Therefore, he contended Robinson was entitled to recover damages for their breach of an agreement which he knew Harman was not entitled to make. Harman paid £25 into court as this exceeded Robinson's expenses in preparation of the lease claimed, and there was no further liability in damages. The decision in this case was that Robinson successfully recovered damages for his expenses and for the loss of the bargain, where a party agrees to grant a good lease in full knowledge that he does not hold the full title. The other party may recover damages which would have so far as possible placed him in the same position he would have been had the contract been performed. The two usual methods of assessing this are difference in value of cost or cost of cure. The court will generally use the more appropriate one in this case. Sometimes reliance loss may be sought where loss of expectation is difficult to prove. The aim of reliance loss is to put the innocent party in the position he would have been had the contract never been made. This is that is an indemnity for his out-of-pocket expenses incurred in reliance on the contract. And the case in regards to this was the case of Anglia TV against Reed, 1972. In this case, the claimant, Anglia Television, engaged Oliver Reed to play the leading role in television play. Subsequently, Reed pulled out and Anglia was unable to find a replacement. They abandoned the play but had incurred expenses amounting to £2,750. whilst damages generally seek to put the parties in the position, it was held that they would have not been in had the contract been performed. The parties may elect to claim reliance loss and recover expenses incurred in an abortive transaction. Thus, Anglia was able to recover their expenses from the defendant. There are many types of losses that have been claimed by innocent party. Damages or for disappointment or mental stress are not generally awarded, as in the case of Addison Gramophone Company Limited 1909, unless the contract is, for example, a holiday contract by Jarvis Swan Tours 1973. Remoteness of loss. The innocent party may only recover damages for loss suffered as a result of the breach, provided it is not too remote. The aim of damages is to be put him in the position he would have been had the contract been properly performed. The principle of remoteness are given in Hadley and Baxendale 1854 and provide that the following losses are recoverable: all loss which flows naturally from the breach, all loss which in the contemplation of the parties at the time the contract was made as a probable result of the breach. If the loss does not fall within the above categories, then it will be too remote and will not be recoverable. The rule in Hadley and Baxendale has been interpreted to mean that only loss which is within the reasonable contemplation of the parties may be recoverable. The court ruled in favour of Hadley and the court held Baxendale should have known that the delay in delivering this would result the mill remaining shut down. So remoteness of damages. The damage must be not too remote in that it must have been reasonably foreseeable, and it is an objective test. In overseas tankship case, UK Limited and Mortstock and Engineering Co Limited, so the Wagon Mount case 1961. The eggshell principle, this is where the defendant must take victim as he finds him, so will be liable even if they suffer from a greater susceptibility or weakness to harm than a normal person. Intervening acts, novus actus interveniens. The courts has to decide if a new intervening act broke the chain of causation. So if this is the case, then the defendant will only be liable for the injury or harm caused by the negligent acts prior to the intervening act. Regarding the final loss, the claimant may take action against the third party. Mitigation. An innocent party cannot recover for loss that he could have avoided by taking reasonable steps. This is sometimes expressed as the duty to mitigate. This does not apply to actions for the price of goods delivered. Such an action is action for an agreed sum and not action for damages. Although there is no duty to mitigate before actual breach occurs, the innocent party should not aggravate the loss. It is the defendant to prove the plaintiff has failed to mitigate his loss. As in the case of Pilkington, and Wood 1953. In this case, the claimant purchased a house which turned out to have a defective title. Shortly after the purchase, he obtained employment elsewhere and needed to relocate. He had difficulty in selling the house due to the defect in title. He brought an action against his solicitor for his negligence in failing to notice this defect. It was held in this case that solicitor was liable for the difference in value between what it was worth without the defect and what it was worth with the defect. However, he was not liable for the added loss caused by the need to move, as it was not in the reasonable contemplation of the parties that he would move so soon after the sale. On the issue of mitigation, the claimant has entered to sue the vendor, although the court held that there was no duty to sue the vendor in order to mitigate their loss arising from the defendant's negligence. There is another case in regards to duty to mitigate, and it's the case of Pearson and Saunders, 1919. And in this case, by the terms of the contract, the defendant was to deliver goods to a claimant on a monthly basis, and the claimant was to pay for the goods within 1 month of the delivery. The contract was to run for 9 months. The claimant received the goods at a discounted price because he had committed to purchase from the supplier over the 9-month period. The claimant was late in making the first installment, and this amounted to a breach of warranty, not entitling the defendant to repudiate the contract. The defendant refused to continue with the original contract, but told the claimant that he would deliver the goods in the future if the claimant paid cash on delivery, and would still let him have the goods at the discounted price. The claimant rejected this offer and purchased the goods elsewhere at a higher price. He then sued the defendant, claiming the difference between the contractually agreed price and what he actually paid for. It was held that the claimant was not entitled to damages. He was given the opportunity to purchase at a discounted price, but rejected this, and he was under a duty to take reasonable steps to mitigate his loss. The offer was a reasonable one, and one which the claimant could easily have complied with. Then you've got defences in negligence. So you've got contributory negligence by the claimant, which is the Law Reform Contributory Negligence Act 1945. Damages will be reduced. The claimant has to take reasonable care to protect himself, and consent. So voluntary non-fit injuria, illegality. So claimant can take action against a defendant for a defective product where loss has been suffered in contract, tort, or under the Consumer Protection Act 1987. Statutory duty and liability is strict. So now we're going to look at 5.3 is to compare and contrast the different measures used for assessing damages. So measures of damages in contract, damages awarded for breach of contract. Generally, the purpose of an award of damages for breach of contract is to compensate the injured party. The general rule is that damages are meant to place the claimant in the same position as if the contract had been performed. Damages are usually awarded for expectation loss, so loss of a bargain, or reliance loss, which is wasted expenditure. In some cases, the court may award damages which go beyond a strict measure of compensation. Examples of non-compensatory damages include nominal damages, aggravated damages, restitutionary damages, and account of profits. Damages for the breach of contract are subject to the principles of remoteness, causation, and mitigation. Remoteness. The term remoteness refers to the legal test of causation, which is used when determining the types of loss caused by a breach of contract or duty which may be compensated by a damages award. Legal causation is different from factual causation, which raises the question whether the damage resulted from the breach of contract or duty. Then we've got, accordingly, once factual causation is established, it's necessary to ask whether the law is prepared to attribute the damage to the particular breach, notwithstanding the factual causation. And then a damage which is too remote is not recoverable even if there is a factual link between the breach of a contract or duty and the loss. And the cases we can look at in regards to the remoteness of damages is the most important case, which is the, as mentioned on the next slide, which is the contract one. In contract, the traditional test of remoteness was set out in Hadley and Baxendale, 1854. The test is in essence a test of foreseeability, that is, the loss will only be recoverable if it was in contemplation of the parties. The loss must be foreseeable, not merely as being possible, but as being not unlikely. And the knowledge that is taken into account when assessing what is in contemplation of the parties comes under two limbs. First, the knowledge of what happens in the ordinary course of things, which is imputed to the parties whether or not they knew it. Second is actual knowledge of special circumstances outside the ordinary course of things, but was communicated to the defendant or otherwise known by the parties. Following the decision in the House of Lords in the Transfield shipping against Mercator Shipping 2008, it is clear that the remoteness test is about identifying the scope of an implied assumption of responsibility by the defendant in the contract. It is therefore requires an assessment of the common expectation as to the scope of the defendant's liability. Another case in regards to that where the application can be seen for remoteness is the Victoria Laundry case, Windsor Limited, Newman Industries, 1949. In this case, the claimant purchased a large boiler for use in their dyeing and laundry business. The defendant was aware that they wished to put it to immediate use and knew the nature of their business. The delivery of the boiler was delayed in the breach of contract, and the claimants brought an action for the loss of profit which the boiler would have made during the period in which the delivery was delayed. The claim contained a sum for a particularly lucrative contract which they lost due to the absence of the boiler. It was held in this case by the courts that the claimants could only recover losses which were in the reasonable contemplation of the parties, which include the loss of profit that could be expected from the lack of use of the boiler, but the claimant could not recover the loss of exceptionally lucrative contracts since the defendant was unaware of this contract. So the next one is tort. So in relation to some types of tort, in particular negligence and nuisance, the test for remoteness of damage is whether the kind of damage suffered was reasonably foreseeable by the defendant at the time of the breach of duty, such as the ownership tankship case and Mort Stock Engineering Limited, the Wagon Mound number 1, 1961 case. The defendant will be liable for any type of damage which is reasonably foreseeable as liable to happen even in the most unusual circumstances, most unusual case, unless the risk is so small that a reasonable man would in the whole circumstances feel justified in neglecting it, as in the Heron number 2, 1969. Providing that kind of damage is reasonably foreseeable, it does not matter that the manner of the infliction or its extent was unforeseeable, as in the case of Hughes and Lord Advocate 1963, and Vacville Engineering Company and BDH Chemicals Limited 1971. And however, following the decision, the House of Lords in Bank, Bruckles, Lambert and Eagle Star Insurance Company 1996 stated that it would appear that the traditional principles of causation and remoteness have been superseded or at least supplemented by a need to determine whether that damage lies within the extent of a defendant's liability. The next one is causation. So a principle used principle used in the assessment of damages for breach of contract or tort. Losses may have been foreseeable at the time of contracting or at the time of breach of duty in the case of tort, but they will only be recoverable if those losses were caused by the breach of contract or duty. The claimant must prove on a balance of probability that the breach caused the loss. It is not sufficient for the breach merely to provide opportunity or occasion for the claimant to injure himself. The so-called but-for test is used as primarily the filter if the loss does not have, it would not have happened in any event, then the breach could not be said to have caused a loss. Then we've got mitigation. The rule of mitigation requires a claimant to take steps to minimize its loss and to avoid taking unreasonable steps that increase its loss. An injured party cannot recover damages for any loss, whether caused by a breach of contract or breach of duty, which could have been avoided by taking reasonable steps. The claimant is said to have a duty to mitigate. However, this is not a duty enforceable by anyone. Rather, it's a recognition that the claimant fails to do so. Its damages recovery will be affected by that failure. 5D1, assess the amount of damages that can be claimed for a specific breach of contract. So what is a breach of contract? Here, each party to a contract is entitled to perfect performance of the terms of the contract by the other party. A party will be in breach of contract or break the contract when they fail to perfectly perform one of the warranties, conditions, or inanimate terms, which are the terms of contract that they have been promised to perform, which we did in the last sessions. The most common form of breaches are defective performance, where the contract is partly performed but not to the standard required by the contract. Delayed performance, where a party does not perform on time in accordance with the timeframes required by contract. Complete non-performance, a party does not do anything to perform the contract. The consequences of breach of contract depends upon the type of term which has been broken. Breach of contract claims. In contract law, a breach of contract gives rise to cause of action where the innocent party has a right to monetary compensation, that is damages for failures to perform the contract. If it is serious enough, the right to terminate the contract, and in some cases may obtain specific performance of the contract or an injunction to restrain further breaches of contract. And when we look at specific performance, this is an equitable remedy which is available at the discretion of the judge, and it's an order by the court requiring one party to perform their contractual obligation, whilst it is often said that the contracts are made to be performed and parties should be held to their contractual obligations. The courts are often reluctant to order a party to unwillingly perform the contract, and specific performance is the only available in limited circumstances. And the cases for specific performance is a case called Cohen and Roche, 1927, and in this the claimant owned a furniture shop and entered an agreement to purchase a quantity of Heppel-White chairs to sell in his shop. The defendant, in breach of the contract, refused to deliver the chairs. The claimant sued for breach of the contract and sought specific performance for delivery of the chairs. It was held by the court that the court refused to grant a specific performance. The claimant would be adequately compensated by an award of damages. The chairs were considered ordinary articles of commerce and of no special value or interest. The claimant could have purchased the chairs elsewhere, as the court stated. So breach of contract claims, how it works. What are the elements of breach of contract? So we've got express contracts and implied contracts, express terms and implied terms. types of terms of contract, condition, warranty, and inanimate terms, which we discussed previously in the previous learning outcomes and sessions. Consequences of breach of contracts, what happens, repudiated breach, anticipatory breach, assessing repudiatory breach, what happens after repudiated breach, affirmation and repudiated breach, and consequences of affirmation and consequences of termination of contract. If you go on to each one, you can go onto there to get more information around each area, and the links are available for you on there. Alternatives to repudiated breach, we've got material breach, fundamental breach, substantial breach, and serious breach. And then we look at what about any breach of contract, what if there's no termination clause at all, and illegal contracts and breach of contracts. And if you just link onto them, it'll take you to the link, and you could look at them in regards to more additional resources in regards to carrying on with the learning outcomes and completing the assignment. So references that have been used in regards to this session is Contract Law by Taylor and Francis, 2017, text, cases and materials. Also the Thomas Reuter's website, Practical Law, Hallilus, breach of contract meaning, and Thomas Reuter in regards to any sort of contract issues and case law. We've also looked at e-law resources you can look at in regards to this. Also, if you go onto Moodle, there's loads of additional resources in regards to trying to identify any sort of case law around it, and also any sort of journal articles, case examples are on Moodle for you to look at. And please look at these resources to complete the learning outcomes. The next session we'll be doing will be trying to look at the assignment discussion for this unit, which is contract law, and we'll go through what the elements are and any sort of extension activities that you need to do to get a better grade in this assignment. Thank you for attending today's session, and the next session will be on assignment discussion on contract law. Thank you.